Hello, everyone. Welcome to today's RD2RD Live Show. I'm your host, Megan Boitano, owner-founder of RD2RD. And today we have Jessica Manganello on from New Leaf Legal. And thanks, Jessica. So we're going to be talking about trademarks. And RD2RD is a registered trademark, but to be honest, when I started my business, now it's more than 3 years ago, I didn't really understand, one, what a trademark was, what it did, if I needed one, should I spend the money on one, what am I actually getting, and I did make that decision to go through the process, but looking back, what I thought, the reasons, and when I got through the end of it, it was my understanding of the topic changed dramatically. And there have been a little, some, I don't want to say bumps and bruises during the process, but I felt like this topic will come up from time to time, everything from, how much does it cost to, do I really need one? When should I get a trademark? Well, what am I actually trademarking? So that's kind of what we're going to talk about today. Jessica is an attorney, and she's actually been kind of with RD2RD from the very beginning, from writing my terms of use and privacy policy to shepherding through my trademark registration. I feel like you've been part of my business journey, and I'm appreciative of you and appreciate that you come on today.
Yeah, same here. Thank you for having me.
Yeah. So before we dive into the topic, I wanted to just start out and have you tell us a little bit about your background and your business, New Leaf Legal. And tell us a little bit.
Thanks. So New Leaf is almost 12 years old. I'll be 12 in November. Yeah, it's exciting. It was a group of us who were at a large firm when we just graduated from law school. We spent 3 years there. It was a really interesting experience and model because they wanted us to work with small businesses and startups and to start to create our business development opportunities, which isn't typical for new lawyers. Usually you're just workhorses. So that was really great, except after a few years. They decided they wanted us to move up. They're like, now that you know what you're doing, you know how to build business, we want you to go more mid-market, more commercial, much bigger companies, move more into litigation and things that had a bigger, ticket price, essentially, which is normal, except that the three of us had really realized during those 3 years that we loved the people we were working with. We loved working with small businesses, helping companies that couldn't necessarily afford legal services, especially the big firms, and even with solos, it can be really difficult to find someone with expertise in business and intellectual property that's affordable. And so we decided we wanted to keep doing that, and we didn't want to move away from it. So we started New Leaf, and then over the years, with different life changes and everything else, I've slowly bought everyone else out, and so now I run the firm. And kind of just stay true to the mission, all fixed fees, so it's easy to budget for small businesses, making sure that we're kind of acting like an outside in-house counsel. So working with companies, so we are with them from the beginning when they're an idea on the napkin, and hopefully, ideally, working with them long-term as they grow and expand, and we do help businesses when they sell or close, and with succession planning and that kind of thing. So it has really worked out great. I've learned a lot and expanded a lot. It also means I'm working with people who are super excited and passionate about their businesses, which is really nice because as a business owner, when you get kind of dragged down and you don't understand why you're doing this, I'm constantly talking to people who are passionate and excited, and it's kind of contagious. So it's been good for me too. And I really like trademarks. It's super nerdy, but I definitely enjoy them and like talking about them.
I remember the call where I, decided I wanted to move forward, and I remember getting off that call going, whoa. I felt like I'd been hit by, I don't want to say a truck of information, but the thing, I always love talking with you because, I've talked to other attorneys, and I always don't feel like the law can be really complicated, but what you always do is provide it in the context of what makes sense for me as this business owner, rather than telling me everything anybody could know. Like, you kind of know where I am right now, and you boil it right down into something that I can understand and act upon. So that was really helpful when it came to the trademark conversation. So I guess when I started the process, put some context for people. I had launched my website, and it was about 6 months later where I thought, well, I'm getting a decent response to this, and what do I actually own? Could somebody just start using my business name? Do I need to protect this? Does anybody really want to? Like, is it really valuable? Do I need to even protect this? So I think I want to start there. Like, what are you actually protecting with a trademark? Because it's like not a patent, it's a trademark.
Right.
So, and why even have one? So I think just start there.
Yeah. So trademark protects your brand. It operates as a source identifier. So your logo, your name, whatever a customer is going to look at and would immediately know, oh, that's your company that I'm getting this product or service from. Logo, name, tagline, it can be, kind of variety of things. If you're thinking even bigger with more notable brands, you get, trade dress, like the way McDonald's looks and the way they have everything set up in all their color schemes, or Tiffany with the, they have a trademark over Robin's Egg Blue on jewelry boxes. No other jewelry stores can use that color blue, that sort of thing. So it usually for most businesses starts out with like a name, maybe a logo, and then things can evolve over time. As soon as you start using a name, you have common law rights to it. But those are really limited to your geographic area where you do the majority of your services, and you can't really sue in federal court, and there isn't much you can enforce, which is why people will go for federal registrations. When you have a federally registered trademark, you have a presumption of national exclusivity. So, say I'm just providing legal services and I do most of my work here, under New Leaf in Massachusetts, and, North Shore of Massachusetts. Someone in every other state could start calling themselves New Leaf Legal and providing the same services as me if I don't have a federally registered trademark, because my trademark rights are common law and they're only available in the North Shore of Massachusetts. In fact, someone on the South Shore could probably start using the same name.
Okay.
Versus if I have a federally registered trademark, which I do, it's nationwide. So it doesn't matter where I'm providing the services, which becomes really important these days, I think, as we go along. The internet is a thing. It's not going anywhere. And anytime anyone is doing business, you have an online presence and you're visible nationwide. So having the name really kind of protects your brand, your identity, and it actually is meant to protect the consumers. By giving you that exclusivity, your consumers know that they're working with you versus maybe another business that might make you look bad, right? That doesn't provide the same level of service that you do, and the consumer gets confused thinking they're going to you and they go to them.
Right.
Yeah.
So the other topic is there's different kinds of trademarks, right? There's the word mark or your traditional service mark, and then we all know there's credential marks where, like, registered dietitian, being a credentialing mark. Is there some significance to that?
Not too much. I mean, a little in the application. If you want to get like a credentialing mark, if you're going to be providing credentials and assessing third parties, then when you fill out your application, you have to indicate that, and that you have metrics and an actual credentialing system set up. When it comes to like service marks, versus trademarks, there really is no difference. It's just kind of a term used for anyone who's getting a trademark on a name for services that they provide. But at the end of the day, you're still getting the same thing. You're getting a registered trademark federally for all of the above. You can put the little registered R next to your name once you have it, and it indicates to the world that you have a registered trademark, and you get the same statutory rights to protect your mark. So not much of a difference there.
Okay. So back to this, like, timing. When is the right time? Is there a right time to go after a trademark? I mean, what's the timing and what's common, I guess?
It's a really good question. It's definitely different for everyone. And it usually comes down to, budget, how tied you are to the name or how committed you are, and then whether or not you think it's something that other people will gravitate towards. Ideally, you're going to have protection from day one. As soon as you launch, you're going to have that trademark filed, either protected as an intent to use or an actual use. And you'll know that from day one, you can stop anyone who's infringing on your mark, and often more importantly, no one else can stop you from using your mark. If that lawyer in California gets a trademark before I do, they can't shut me down, right?
Correct.
So you get that assurance. Of course, trademarking isn't crazy cheap. Between legal fees and filing fees, you're looking at somewhere between like, $1,700 to $2,500 to file a trademark. So if you have the money up front, great. But once you file that mark, you do want to stick with it, because if you make any significant changes to your name, drop a word, add a word, change your logo, that's considered a new trademark. So you don't want to move forward with the trademark until you know you're going to stick with that name for the foreseeable future, when you can afford it. A lot of what goes into it is people want to wait and see, well, maybe I get some proof of concept, and maybe I get some revenue before I spend all this money committing to this name. And that's perfectly reasonable. If you do that, I would just say monitor the trademark office, monitor other people's use, keep doing searches out there. Because if someone does beat you to the trademark office and they get a trademark before you do, or just their application before you do, if they get that mark, they can stop you from using your name. So you want to make sure that you're at least keeping track if you need to wait a little while.
Yeah.
And if you think it's a name that is like, well, this is really catchy, and once people start hearing it, they're probably going to start using it, especially if it's, tied to an industry where you're like, oh, this is like, I use some certain industry terms that I think people are just going to start using the name of this method or this process or something. Then you might want to take trademarking more seriously and get that done earlier as opposed to later. Versus something like, I always use myself as an example, like New Leaf Legal. It's not necessarily something that every lawyer is going to jump on, right? So you can kind of assess based on your business and your budget, and your level of commitment when you want to do that.
Yeah, I remember one of my motivating factors is I saw people starting to use my business name as hashtags and different things independent of me, and I thought, okay, so is it catching on? And what if somebody likes that? It could be used more broadly, and I felt that it was one that I wanted to stick with. But I also had a tagline or a my slogan, and deciding not to pursue a trademark of the slogan. And then there's also your logo, the actual visual look of the logo. So I thought, well, I might change that someday, but I thought I would do the most important. Is there a most important thing to trademark first?
Usually it's the words. It's the actual name of your business or brand. That's usually going to be the most important, because if you protect the words, then you have protection over them regardless of how you design them. So regardless of the logo or presentation, you have those words covered, which means that if someone else uses them, but they put this really crazy design around it, it's still going to be an infringement of your mark.
Okay.
For logos, that also kind of depends. If your logo is just the stylized words, then usually the words are the better way to go. If you have a very unique stylization where you wouldn't want someone to use that type of design element in your industry with different words, then it might make sense to move forward and protect the logo as well, but I would usually file them separately. Filing the logo, if it's primarily your words, just stylized, does give you some protection over both. So if you have a really limited budget, you might just file that so you get a little protection over each in the meantime, and then you can always expand out and get more. But it kind of depends on your logo. It depends on how prominent the words are, how they're stylized.
That's why you talk to someone like you who will give you the good advice.
Yeah, exactly.
And I think that was part of, the conversation that we had. And I, kind of remember this, like, I don't want to say like gut check moment when we had this, conversation about filing, where I was like, well, okay, what if, like, there's no slam dunk. It's not like, well, I'm just going to go out and get this trademark. You're applying. And I think that, we're going to talk through that process, that there is a lot of, the trademark and patent office goes through to make sure that what you're applying for doesn't kind of infringe upon other people's marks. But before you even apply, you did this due diligence where you came and gave me this mind-boggling report of all of these other marks that could potentially, that were possibly, I don't want to say competing. What is that whole process? When I'm like, hey, Jessica, I want to trademark RD2RD. You go into like trademark lawyer mode. So what is that? What's happening?
Yeah, so usually it's a two-part process. First, you want to run the due diligence. So for that, you can do that directly with the trademark office, although their website's not great. So I actually do have a service that I pay for that's a big database that mines the USPTO database. It makes it a little easier to search and find things. Because when you're looking, and if you're doing it yourself, and you're looking to trademark and you're going through, the USPTO is looking at everything by industry. They refer to it as a class. So there are classes, every class has a different number, and there are a bunch of different things that are included within each class. And so you want to see what other marks are in your class or in any class that might be similarly related, like, downloadable software is in a different class than software as a service, but obviously those are, similar. And a consumer would consider those to be similar. So when you look through, you want to look through in all these marks and different things. You don't have to worry about marks that are totally different. Like, I have a trademark in New Leaf Legal for legal services, but there's a trademark for New Leaf over like a construction company, a video production company, merchant services, and that's all okay because, the presumption is the consumer's not going to look at us and be like, oh yeah, probably the same company. So you want to look through the different classes, but you want to look through everything. So, trademark examining attorneys will look and see, do you have common words with other marks? So that like, are the big words or the most prevalent words in your mark similar to another mark? Are they spelled differently, but they sound the same? A lot of people will change an S to a Z or drop a vowel, and they're like, oh, great, it's totally different. No, it's not. They're gonna assign other meanings. They're going to assign other spellings, and say, okay, we're going to consider this mark as if it included all these things. And then we're going to look around and see who has a registered trademark already in our database, and if there's anything that's going to be similarly confusing. So the searches can be expansive. They can be a lot, especially if you're in an industry or if you're using, with a lot of branding, and if you're using any words or images that are very common in your industry, you're going to see a lot of activity, and you're going to have to try and differentiate yourself from those other marks. Because when the examiners look at it, again, I keep talking about, like, is the consumer confused? Like, trademark is actually about consumer protection. So they're looking at it and saying, okay, if we give you this mark, would a consumer be confused about who they were getting services and goods from?
Right.
So they don't want to give you anything that's similarly confusing to another mark. Mm-hmm. You also can't have anything that's completely descriptive. So like my mark, New Leaf Legal, I actually only have protection over New Leaf because my competitors need to be able to use the word legal. So the same would go for any of your marks. Anything that's purely descriptive of what you do wouldn't be something that you could protect either.
So for example, something like gut health dietitian, that's kind of descriptive, right? In theory, or not? Like, give an example of something that's descriptive versus kind of, unique, I guess.
Yeah. So if I did, Boston law practice, that would be completely descriptive because I'm a law practice based in the Boston area, right?
Got it.
Gut health dietitian, if you're an actual dietitian, dietitian would be descriptive. Gut health might be, if your whole focus was on gut health, then the examiner would probably say, okay, this is literally just describing what you do. If the language you choose and what's on your website isn't like specific to that, or you're using more like the biological language on your website, they might say, well, it's kind of suggestive of what you do because you're actually focusing on diet, not necessarily gut health.
Right.
So there's always kind of that line where you're like, does someone have to take a little bit of a leap to get there?
Yeah.
Versus like fried chicken restaurant that serves fried chicken, right? Like Kentucky Fried Chicken based in Kentucky wouldn't be able to get a trademark.
Got it. So this whole looking at, what's the potential that I'm going to be successful when I file my trademark application, and looking at how do I structure it so that there's the strongest likelihood that I'll be successful. So I remember getting the report back from you and us talking through it, and you're saying, this is the class, Megan, that we're going to, apply for, because I'm not applying to cover construction companies. Like it's a specific class. I think it was 35. And then this description of what I do, what my business is about. And then, that was your kind of a recommendation was like, I think you had a strong likelihood. Obviously, there's no slam dunks, right?
Right.
Is that fairly common for you? Do you oftentimes go and say, you're not going to get this?
Oh, yes, that happens. Yeah.
Okay.
A lot of the time there is a mark that's like right on target and it's already been filed. And so I would say, before you really get invested in a name, at least go to the USPTO and run a search directly and just see if there's anything that's exact in your industry.
Because if you don't, right, someone could say that your business that you're investing this time in could be confusing for someone who has an established mark, right? Perhaps.
Yeah, that you might spend a lot of money and time and effort. And I actually see this happen a lot with like branding companies. So a client will hire a brand company to help create this whole identity for them. And brand companies don't usually run trademark searches. And so you've just spent, sometimes people are spending 10, 15, sometimes hundreds of thousands of dollars for a brand identity. And then you go and do a search, you're like, oh, no, your competitor already has this trademarked. You're going to have to come up with something new. So it's good to at least look and see if there's a direct problem, early on, before you invest, before you go to the printer and put everything out, before it's all over your website. You want to take a look at that. And through the due diligence, it's seeing what else is out there and then figuring out what class language is going to work, because the USPTO has a bunch of pre-written class language, and some of it you can modify and some of it you can't. And you can write your own class language, but usually they've got enough there that you can really define what you do. So it's choosing that language and figuring out, based on potential issues with other marks, how can I distinguish myself? How can we set the application up to have the best chance of success? So once you figure that out, you put in the application. If it's an intent to use, you don't have to show any samples of use. If it's an actual use, then you have to provide screenshots from your website or images of your services out in the marketplace. If you're at a farmer's market, a picture of you at the farmer's market, that kind of thing. You put all that in through the application, and then it's kind of a waiting game. The USPTO takes about 4 months to assign an examiner. It's been a little longer lately. And once they do, the examiner will look at your application. If the examiner likes everything they see and they think, I'll give you this trademark, they move you on to the next stage of the process. If they have any issues, they'll issue what's called an office action. The office action might ask for, I just want better samples of use, give me some more screenshots, give me a better explanation of what you do. I want some clarification in your class language, or I want to verify some dates.
Okay.
No big deal.
So when you say examples of use, can you trademark something that's not yet in use? You mentioned intent to use, and then because I trademarked something that was already in use, but let's say someone really wants to protect it and they don't want it to get out there at all, and they want to trademark it as an intent to use. What's that?
Yeah. So you can file an intent to use mark, which is basically the exact same process, except you're telling the USPTO, I'm not using it yet, I'm intending to use it in the future. So it acts as a placeholder. You'll go through the process, they'll decide whether or not to give you the mark. And if they do, then you have 6 months to provide proof that you're actually using the mark. And that's when you have to put in those, screenshots from a website or pictures or images. You can actually file for extensions, up to 5-6 month extensions. You actually do get a pretty long time to prove that you're using it. Right. And as long as that mark is in process, you have protection, and the USPTO isn't going to grant anyone else a similarly confusing mark. So it really does act as a placeholder for your rights. And then once you do show them proof of use, it converts to a registered trademark, and now you have the registered trademark, and your protection is retroactive to your filing date.
Got it. So I'm going to take a quick pause because we had a question. I think it's a really good one, because I think we're registered dietitians, not legal people. So the question was really around, okay, so what's the difference between trademark and copyright? Which I was like, okay, we should probably distinguish the two, because copyright, but this is mine. What are we talking about here?
Right. So it's fun. There can be a lot of overlap between the two. Like if you create a logo, you have a copyright over that logo, but because you're using it as a logo, it's also a trademark. So I'd say in terms of what, your industry, your brand name, your logo, your taglines, anything that when a consumer hears that, it triggers them to be like, oh, it's that company. That is your trademark. The copyright would be over your content. So content on your website, photos that you've taken, if you have any like manuals or handouts or how-tos, any processes and methods that you've created, if you have like, a diet plan, or a menu plan, or, tools that you have written down that you use to walk your clients through the process. Those are all things that would be copyright. Now, if you come up with like a fun name for that assessment or for the tool or for the plan, that would be a trademark for those copywritten materials.
Got it. That's a good distinguishing. I appreciate that. So now, what are some, you mentioned during this application process, you might get like an office action back from the examiner, but let's say that you're able to provide additional, use or whatever it is that this examiner wants, and then you make it to the next step. So this is could be a hurdle, right? This published for opposition. So what does that mean?
Yes. So once the examiner has cleared you and said, yes, you've addressed all of my concerns, moving you forward, you get published for opposition, which means that the trademark office publishes your name in the Trademark Gazette that they put out every month. And they say, hey, world, we're going to grant this trademark unless you have some reason why we shouldn't, speak now or forever hold your peace kind of thing. And so they have 30 days to put in an opposition. They have to have a legitimate challenge. It can't just be anyone be like, I don't think you should grant this. Like, they have to be someone who has like legal claims to the name or some reason why you shouldn't get it. And they can put in their, opposition. And once they do that, it kind of puts you into this like mini litigation where they put in their complaint about why you shouldn't get it. You have an opportunity to respond. And then it kind of goes back and forth with some discovery and some additional meetings. You might have, telephone calls and hearings. Everything goes through the USPTO. It is all online. It's always been online, which is actually kind of nice. It's a really succinct process with deadlines and dates, and everything's remote, so you don't have to travel. And, usually gets resolved. Either there's like a settlement or some sort of concession, or the TTAB board does look at it and decides whether or not the challenger really has a good claim and will issue the mark. That's really rare, though.
Okay.
Typically, if that happens, you saw it coming. Part of that due diligence is looking to see who else is out there, who's out there common law wise, who's out there on the register, and are there a lot of marks that you see on the register that have been challenged? So you kind of know that maybe there's a bully out there who's going after people, and so okay, I might trigger them. They might come after me.
Right. So which I think was important because in the due diligence you went through and said, oh, this mark was abandoned, or this mark is dead, or like what were some of the, why, looking into a little bit more, why did that happen? For people who you might have some potential for, you're stepping on their turf a little bit.
And that I see a lot. There are certain companies, certain brands out there. It's also there are certain trademarks where maybe the brand doesn't do that. Maybe they're fine. But the examiners are consistently saying no, because of this one mark, we don't think any of these other marks should be granted. So you really get a sense of that, through the due diligence. You tend to know if you're going to receive an office action, and if it's going to be a big one, you tend to see a challenger coming. So usually that 30-day period is just a waiting period.
Got it.
Because, part of the due diligence process is figuring out, okay, what am I in for? And do I want to continue? Do I want to put in the money to filing if I know that I might have all these challenges or not?
Right. And I think going back to the point that you made before, even if you're not considering, a trademark, or it's not in your budget, that when you're thinking about putting all of this time and effort into a business, to at least invest in having somebody search to make sure that whatever business you want to call yourself, you're not picking something that, one, you could end up with someone coming after you, or you're not going to be able to protect in the future should you want to, which I think is super. When I had my business name, I got some suggestions. That was part of the process, that, they went out and looked to see if anybody was using that term already. So anyways.
Yeah, and you definitely want to look and see, not just registered trademarks, but is anyone out there in the marketplace using it? Because, you don't want to step on their toes, you don't want them to step on yours, but also those people are a potential challenger when you do file your trademark. If they all of a sudden go to file their own,
Right.
and they get an office action saying, hey, you're too similar to this other mark we have pending, they're the ones who are likely to challenge you.
Right. Yeah. And I, think it's interesting that, what we think, like I thought, oh, well, if you have a trademark, you have protection of that anywhere at any time, use of anywhere. And I was like, oh, there's classes, and it's like, could be slightly different in how it's used. That there's a lot more nuance. There's a lot than I had any idea existed. And so, I'm not an attorney, so I don't like jump into these conversations, except usually say, you should talk to someone who knows a lot more than registered dietitians know. I'm just saying, just as a suggestion, that if you need advice on trademarking, I would probably, seek out someone who's an expert. And I think that's one of the nice things about you and the way you support, like you focus on small businesses and you have really upfront pricing where it's not this, we're going to charge you this much per hour and we're not going to tell you any idea of how long it's going to take. You're like, hey, Megan, I'll do that for you. This is how much it costs. And I'm like, I can fit that in next quarter or something, or whatever it is, it's realistic. So you're like, I can do this and it's not going to be some scary unknown bill that I don't know how much it's going to be. So I appreciate that.
No, thank you. And I come from a family of entrepreneurs. And I think that's why I have that value set, because I saw them get those surprise bills and it's never fun. And I would also just put out there as a word of caution as you're doing this, either use an attorney or do it yourself. And, if you can't afford an attorney, there are definitely a lot of services out there. There are free office hours. There are business plan services, Center for Women in Enterprise, and local economic developments for your city that usually have a relationship with a lawyer who can at least give you some advice. I definitely suggest avoiding third-party services like Trademarkia and LegalZoom and Rocket Lawyer and all these, only because they aren't lawyers. They legally can't provide you with legal advice. So you end up spending a lot of money, and they basically just have you do it yourself, but through their portal. And they only allow you to do things like intent to use, and they charge you for things that aren't actually fees that you have to pay, and they do it all wrong, and usually almost always get an office action, and then you have to pay to respond to the office action, which they will make you do, but charge you a handling fee. So basically you spend a lot of money for nothing. Which is why I'd say, if you're looking at alternatives, you're like, oh, an attorney just isn't in my budget right now, you're actually better off doing some research and filing it yourself. You'll save a lot more money that way and probably see a lot more of the issues coming if there are any.
That's really good advice. I'm going back to a question here about the consequences of not trademarking your business. So says really essentially I could build up an audience that's bought into my business, right? Your name and all these things, but another business could go out and trademark that and then potentially steal or confuse your audience, and you kind of be out of luck from a legal perspective. Is that true? Is that a correct understanding?
Pretty much. Now, if you have common law rights that preempt and supersede, the trademark owner, say you were using it for 5 years and they were using it for 1 and then they got a trademark. Now, they have the national trademark, so they have a presumption of exclusivity, which means it's in their favor and it's up to you to prove otherwise. So you could carve out some rights for yourself and continue using your name. However, it means you're going to have to spend several $100,000s in federal court to take them to court to challenge their mark or to just, confirm your common law rights. And your common law rights are limited. So I think we kind of touched on it before. Common law rights are just your geographic area. They're also just the material services that you were providing. And it affects your damages. So if you were to win against that other brand, you might be able to just carve out your little space. Like I'd be able to continue practicing, but only clients on the North Shore and only these services that I'm providing. I could never add any other services or any other merchandise or any other business line under this name. So it doesn't really give the common law holder much. Most of us don't have hundreds of thousands of dollars to fight it. So you're just going to end up changing your name, even if you have the superior rights. The other thing is, having that trademark can stop someone from getting a trademark and stopping you. But the other thing is, having someone else somewhere else in the country who starts using the name as well. You can't stop them really because they're in a different geographic location than you. So then you have these parallel businesses that are coming up, and it's kind of a race to, see who's gonna be better at marketing and SEO essentially to see who gets shown The other part of it is someone could actively infringe on your mark. So not just an independent company that started using a similar name, but someone who's actually trying to siphon off of your brand. If you have common law rights, you can still take them to court, you can still stop them, but you're limited to actual damages. So if they made $400, that's what you get, $400. Which usually doesn't make sense economically because it's going to cost you thousands of dollars to take them to court, sometimes tens to 20,000 more for like a standard state to state court case. And so it kind of doesn't provide an incentive for them to stop because in their mind, well, we haven't made much money, so our liability is pretty limited. And are you really going to spend the money to chase me? Versus when you have a registered trademark, you get statutory damages. So that can be up to $250,000 per instance of willful infringement, treble damages, and attorney's fees. Okay. And once you send that cease and desist out and say, hey, you're using my trademark, now it's willful, even if they in good faith just didn't know before. Now it's willful infringement. Every single day they continue using it. So you usually get a pretty swift response from people when that happens because now they know it is worth it for you to sue them because they're going to have to pay your attorney's fees and they might have all these punitive damages on top of it. Yeah. So, having that registered trademark helps you make sure that no one else is going to be able to stop you in the future, but it also gives you a pretty nice way to enforce your mark against someone who's like asking for it. Most of the time. So,
that kind of segues into the last topic about disputes over, okay, so now you have a successful trademark, like you're trademarked. Now, what are some common, disputes that can happen? I think kind of let's just be honest, elephant in the room here is I have a trademark that's RD2RD. Okay, it is a registered trademark. How in the heck am I able to have this mark? When you say, well, someone might object to you having a mark that has RD in it.
Interesting question.
Yes.
Yeah. So when you have a registered trademark, one of the things you are required to do is enforce it. If you don't enforce it, you lose it.
Yep.
So you do have to, keep on top of that. You have to watch and see what other people have. But it also means that sometimes, even though you have that registered mark, you might still have someone come after you and take issue with yours. Often you're going to see that coming. It's, either you saw it in the due diligence or you start to see some activity in the marketplace. Usually it's because they're in some sort of danger with their trademark. Again, I said if you don't enforce it, you lose it. So maybe they didn't enforce it. Maybe they let people use it, or maybe it just got away from them and they were fine with people using it, but now they realize it's being used in ways they didn't want. And most of the time, trademark holders will approach it in a kind of diplomatic way. And you can use simultaneous use agreements where, hey, we agree you can use it, but under these certain conditions, since it's, we have some claims to it, especially if you have two trademark holders who are kind of upset with, each other over how the marks are being used. Usually there's an agreement you come to. Others will just go after you and try and cancel marks or make threats or send cease and desist, and there's a lot of posturing. It really depends on who's coming after you and why. It's not cheap for anyone once you have a registered trademark. So, usually at least it's kind of one of the benefits of having that registration. If you have a really big player coming after a little guy, yes, one can outspend the other, but in terms of rights, you're kind of equivalent. And if you're going through the USPTO, you're going through the same process. So it does kind of level the playing field a little, and that they can't just tell you to stop. You're no, I have a registered trademark, back off. Right. So it gives you some more leverage and some more leeway, which makes that really nice. Most of the time disputes are just settled. Even though as a trademark owner, if you were to enforce your mark, you could get all these damages. At the end of the day, you don't want to spend all the money trying to get money from them. And they might not even have the money. What's the point of getting a $2 million, damages assessment in court if they don't have $2 million or they don't have insurance? So, really what you're looking to do is, we just want to end the issue, and stop the infringement or stop the fight. And so most of these things just end up settled, and it's basically having the leverage to negotiate that settlement.
Right. Because, for example, if someone comes after you and says, says a cease and desist, you're infringing upon my trademark and you don't have a trademark. Let's talk about that situation where you decided not to trademark and now you're oh my gosh, someone who has a mark is saying, stop it. What?
Yeah. most of the time you're just going to stop. Because again, you might have those common law rights, and you might be able to carve out that space for yourself, but it's just going to cost you so much money that you don't want to. You also probably don't want them to sue you. And so at the end of the day, it's probably cheaper and easier to completely rebrand. It does suck. It means you lose all that brand equity, all that brand value. If you were hoping to one day be an acquisition target, or if you were bringing on business partners or giving employees equity, you kind of lost a lot of value if you have to start from scratch with a new brand. Plus all the money it costs too. My God, even just printing costs to get new envelopes and letterhead, and to have your web developer go on and make changes, like all these little everyday things, they really add up, and it's a lot of time and effort and money to change your name. And then, the goodwill with the consumer is the even bigger part, and updating all of your permissions and acceptances and your mailing lists, and it's
and I think looking back, it's always nice to have the benefit of hindsight. At the time, it really felt frivolous to me. My business online marketplace might have been making on average $1,000 a month. Like, to invest thousands in a trademark felt, I'm sorry, a little frivolous. Okay. But looking back, having gone through the process, and, obviously my business, it makes substantially more than $1,000 a month. And so that ultimately, knowing that, my investment of time in growing the brand, that I knew this is what I want to stick with, and having you go through that due diligence, I think I could have decided at that point, that would have been the time to rebrand. Like, it wouldn't have been to wait until now and do it and find out, would have been crushing. So for me, if I had found out early on, Megan, this just isn't going to fly, you're not going to get this trademark, or here's all the bumps we're going to have in the road. So, I don't want to, I'm not giving anyone advice, but at least that was my lived experience.
Yeah. And I do think it's interesting in that when I talk to people about this, the perception is kind of this kind of thing only happens to like the big businesses. It's only when you have a big brand that you have a trademark dispute. It's only the stuff that ends up in the news, but it's actually really common. I've had my trademark violated twice. I've had other firms that I had to go to say stop it. I had a client who had been operating as a home inspector for over 20 years, and they went to a conference in another state, and another home inspection company was on the other side of the convention hall, the exact same name, same logo. Totally different company that turned out had like a really bad reputation and had been spreading throughout the software franchise model. And the way they found out about it is someone came up to their booth and was yelling at them about the horrible service they had received. And they're like, whoa, we're not even in your state. What do you think? And so these things do kind of happen every day. I had a client with an amazing logo that another person in the music industry just decided to use because they'd seen it on the internet. They're like, well, I saw a picture on the internet, so it must be available. No. Which was also a fun, like, copyright versus trademark. It's like, actually, there's copyright protection for any image that's on the internet because someone owns it.
Oh.
But also there was a trademark protection. And so her designer had copyright protection over it. She had trademark protection over it. That was fun. But it's one of these things that I think, people don't realize that this is like, an everyday situation, which hopefully you won't ever experience, but most business owners do at some point, because there are a lot of people in this country, great minds think alike. And sometimes, sometimes people see things on the internet and they just decide to use it. Sometimes they independently come up with it. But your business and your brand and the perception of you in the marketplace does become really important. And so it's definitely worth, I think, protecting your brand and making sure that at the very least, no one can stop you from, after, 10, 15, 20 years of building this business, come to you and say, no, you need to stop because I got a trademark. Yeah. And if you really need to enforce it against someone else, you'll have the ability to, if it really is an egregious infringement.
Right. And I think, we could talk a lot, but I feel like if you people, no, but I feel that if nothing else, for people listening to really have the appreciation of the benefit of, calling Jessica, visiting, go to Jessica's website and find a time to meet, and whether you're deciding to pursue a trademark or not, but to really understand the position of your business and what are the potential, challenges that could be there. Yeah. So you really understand what you're pouring your heart and soul into building. to know up front, and then you can talk about the timing. Maybe it isn't right now. Maybe it's in a year from now. What happens if I don't? So you are educated, informed, and able to make the right decision for you and your business without being like, it's going to be too expensive, or I don't understand, or, you're informed, because I think when we're informed, we can make good decisions. That's all.
Yeah. And at least be able to plan on it.
Yeah.
If it's a budget issue, kind of know what the timelines are, know what you're risking and how much you're risking, and how you can fit it in. And also, like, I'm happy to talk to people about how can they monitor the trademark in the meantime. So that way, at least, if you're like, well, I need to get some revenue in the door before I invest in this, I need to make sure this is actually going to work and, last longer than a year or two. That's fine. It's just, keep an eye on it so that if you have to speed up that timeline at all if someone else starts out there.
Yeah, no, that's really good advice. Jessica, as you know, I'm a huge fan, and that whole idea of, should I do the online dial a lawyer as, I'm getting started with my business, but the value of really having had you at each step of the way to have that knowledge about what my business is. Every single time we come to a new situation, it's not like you're re-explaining everything. Like, you understand kind of the basics, and I think that's a lot of the benefit. I wish there were more firms like yours. So go out and tell people to, serve small businesses, because especially, hello, registered dietitians. Thank you for your time today, everyone. There's a link to Jessica's website, and then I also link to a new blog post on kind of essentials for starting an online business. So some of the key items are in there. So I'm glad to be back with the live show. Next month, we'll be on talking about working in group homes and long-term care consulting. So that will be a really fun topic. So we'll be back on every month kind of going forward after I took the summer off. So thanks for joining, everyone. And Jessica,
thank you.
We'll chat again soon.
All right.
Bye.
Bye.